Weird picture, I didn't make sure I was still phone, very heavy moments out there.
Ladies and gentlemen, this is the anniversary of 9/11, so I want to take a little extra time to remember those who lost their lives and for all those who served this country.
Thank you, maybe Sorry.
Commonwealth versus Holden Abston. Holden Abston.
Action.
Are you Colton Abston?
Yes, sir.
You're on 25 CR 0066. Were you born in 1998?
Yes, sir.
Last four digits, social security number 4431.
Yes, sir.
You're here for a pretrial conference. What does the Commonwealth have to say?
I don't know, we have a plea? Yes. We have a plea.
A motion has been tendered. I was just informed that says you wish to enter a plea today. Is that correct?
Yes, sir.
You need to speak up a little bit.
Oh, sorry. Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0066?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you, feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them at the end. I'm going to ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those charges. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting any recommendation, I will wait the pre-sentence investigation report be done by probation pro. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that?
Yes,
So
sir.
step to your left, please, sir. Mr. Hunley, what is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to assault in the third degree, 2 counts, the defendant shall receive a sentence of 5 years on each count to run consecutively for a total of 10 years. He shall serve 180 days in jail, and the balance shall be probated for 5 years with the probation supervised. The defendant shall obtain anger management counseling and follow any and all recommendations of the clinician. And he, of course, will receive credit for time served, and any evidence relating to this case shall be disposed of pursuant to the laws of the Commonwealth of Kentucky.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You doing so of your own free will? Your constitutional rights, as explained to us, is still your desire to proceed with your guilty plea and allow the court to fix your punishment within the range permitted by law. Is that your signature and motion?
Yes, sir.
Okay, you understand that after entering this plea, any future convictions of felonies to be enhanced under persistent felony offender law.
Yes, sir.
I'll accept the agreement or the pre-sentence investigation report to be done by probation and parole is scheduled sentencing on October the 9th.
Thank you, Your Honor.
Okay. John Diamond. Commonwealth versus John Diamond. 21 CR 0054. Are you John Diamond?
Yes, sir.
Good morning. Were you born in 1991?
Yes.
Last four digits, social security number 7313.
Yes.
You're represented initially by Mr. Cross, and now it appears that the Department of Public Advocacy has assumed your representation.
That's correct.
Will you move to your left here? We're on a probation revocation. What do you have to say, Counselor?
Your Honor, Mr. Diamond had a 5-year sentence on assault third. He was positive for meth around July the 21st of this year. He had an EPO taken out against him. It was subsequently dismissed. He also had associated with convicted felon. There was an order entered referring him to drug court. If he wants to do that, the Commonwealth's willing to recommend that. If not, we can have a hearing.
We had talked about maybe sending him to rehab instead of drug court. Is that?
Well, I'm kind of confused. His mother, who's in the nursing home, has repeatedly called my house and repeatedly called my office and said she needed John out of jail so he could help her at the nursing home. So I thought drug court would be a better solution than long-term treatment.
We can do whatever you all suggest, Your
But
Honor.
that's the reason I recommended drug court.
Okay, well, I'll sign it. I won't revoke. I'll sign a referral to drug court and have him interviewed to see if he qualifies.
Yeah, there's one already entered. Mr. Kraus said he's having sex next week.
Okay. And then when you get, if the assessment works and they vote you in, we'll let you out at orientation. Okay,
Sounds great. Thank you.
thank you. Zachary Markham. Commonwealth versus Zachary Markham. 25 CR 0011 and 25 CR 0060. Are you Zachary Markham?
Yes, sir.
Good morning. What does the Commonwealth have to say? We have a pretrial diversion revocation and a pretrial conference.
Your Honor, he has a motion to revoke. He was terminated from the specialty course. And one of the reasons he was terminated, he got a new felony arrest, fleeing and evading first degree. So if we don't have a resolution on that, then we need to, do we need another pretrial or do we need a trial date?
One more pretrial.
Well, let's do a negotiate. What's your negotiation?
October 3rd at 1 o'clock.
October 3rd at 1 o'clock for negotiation. The next court date is October the 9th. Nicholas Purdue. 25 CR 0061. Are you Nicholas Purdue?
Yes.
Good morning.
Good morning.
Were you born in 1992?
Yeah.
Last four digits, social security number 7862. You're here for a pretrial conference. What do we have here?
Your Honor, we've had some negotiation and some offer flow back and forth. I think it's rather one negotiation.
October the 3rd, a negotiation day. October the 9th, the next court day. Both of them are conditions of bond. Cody Smith. Twenty-three CR 0067, Commonwealth of Kentucky versus Cody Smith. Are you Cody Smith?
Yes, sir.
Good morning. You're here, were you born in 1992? Last four digits, social security number 4267. You're on a motion for shock probation. Is that your motion?
It is, Your Honor.
You may proceed.
Your Honor, Mr. Smith has been in jail more than 60 days now. He previously was in drug court but was revoked. What we're asking for is that basically he be shocked out, complete an intensive outpatient program and anger management classes. It's my understanding that the victim has been very assertive that she thinks that he has changed, even back before he got revoked. and that she's wanting him to be out to help raise their children.
So the victim is wife or the mother of his children or?
You're not, they were married and had.
Okay, will you move over to your left here?
And she's present in the courtroom today.
Move over. To your left. What do you have to say, Mr. Stock?
Well, looking at this case just on its face, I would probably be against it, but I would tell you this, the victim in this case was cooperative when this case was prosecuted and told me about Mr. Smith's problems, and we got a plea, and he served quite a bit of time.
Victim was or Mr. Smith was?
And then during this time, she told me she'd seen a big change in him and that she thought he could do this. So I'm willing to go along with it if the court is, but this will be his last change. He violates his shot probation if you do let him out.
She here?
She is.
She'll come around. Never come around. Ma'am, what is your relationship with Mr. Smith? Are you married to him or just, are y'all divorced now or what?
No, we're engaged, but,
Have you previously been married?
no, sir.
Okay. Do you have children together?
Yes, we have
How many
two,
children?
two.
And you were the victim of the domestic violence in this case?
Yes, Your Honor.
How seriously were you injured?
Not seriously injured.
Did you have to go to the doctor or the hospital?
No, no, sir.
And so you're asking the court to shock probate him because you believe you can resume a relationship with him.
Yes, Your Honor.
Well, I'm not trying to embarrass you, but the reason I called you up here is I want to make sure we got you on the record on this thing. Because Mr. Smith, you might change, but unfortunately, there's a lot of recidivism in domestic violence. I don't know why you hit this woman. You know, it's never excusable to do that. But I will tell you, and if you touch her in any way, you're brought back up here, it will be a bad day for you. You understand what I'm saying? I'll sign a motion for shock probation. What kind of conditions? You want supervised?
5 years of outpatient drug treatment, maintain gainful employment, no violation of law by all conditions.
And supervised, and supervised. Okay, I'll sign that order. Good luck to both of you.
Thank you.
Thank you, Your Honor.
You have anybody else that's been transported? No. Okay. We'll go to the out of custody docket. Corey Baird. There's an active warrant for Corey Baird. Victor Barnes. Victor Barnes. This is 25 CR 0059. Are you Victor Barnes?
Yes, sir.
Good morning. You born in 1985? The last four digits, social security number 6457. We're on a pre-trial conference. What's the Commonwealth say?
Have a plea, Your Honor.
How is it?
Phil.
Have you just been informed that you filed a motion, says you wish to enter guilty plea, is that correct?
Sure.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
For the same person that we just identified in 25 CR 0059.
Sure.
Is your judgment impaired today in any way?
Right, Your Honor.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you viewed the evidence in the case and believe you're fully informed?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them, at the end of them. You can tell me if you understand them or not. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering this guilty plea, you give up all those rights. You understand that?
Yes, Your Honor.
I may consider the Commonwealth's recommendation, but finally range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. You understand that?
Yes, Your Honor.
Step to your left, please. Mr. Hunley, what is the Commonwealth's recommendation?
Upon a guilty, upon a plea of guilty to possession of a controlled substance, first methamphetamine, second offense, the defendant shall receive a sentence of 3 years, probated for 3 years with the probation supervised. The defendant shall receive credit for time served. He shall acquire and continue to have gainful employment or do a minimum of 30 hours a week community service. All the evidence gathered in this case shall be destroyed in accordance with the laws of the Commonwealth.
Is that your understanding of Commonwealth's recommendation?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, Your Honor.
Doing so of your own free will.
Yes, Your Honor.
Knowing your constitutional rights, explain to us still your desire to proceed with the plea and allow the court to fix your punishment within the range provided by law.
Yes, Your Honor.
You understand that after entering this guilty plea, any future convictions could be enhanced on a persistent felony offender law. You understand that?
Yes, Your Honor.
That's your signature on the offer and motion.
Yes, Your Honor.
I'll accept the agreement or pre-sentence investigation report by probation and parole and schedule your sentencing on October the 9th. Okay? You meet with probation and parole officer.
Thank you.
Brett Carver. Commonwealth versus Brett Carver, verified CR 0017. You are Brett Carver, so born in 1976, last 4 digits, social security number 5893.
Yes, sir.
Okay, what do we have here?
I had filed a motion to dismiss. I think we were set for a response deadline today from the Commonwealth. As of now, the Commonwealth has filed a motion to have an evidentiary hearing. I've filed an objection to that. I do object to the evidentiary hearing. I think the questions in front of the court are entirely questions of law. I don't think an evidentiary hearing will be dispositive of any of those questions of law.
You want,
In
you
the
want
absence
to
of
so tell me,
here to
what do you
fix.
want for the evidence here?
I would disagree because if you read Mr. Lanham's motion in response, he alleges that we're relitigating the same transactions in this case. And since he wants the court to rule on the record, I want to give the court some background. In the first case of Mr. Carver, he was prosecuted over 2 or 3 checks. I'd have to go back and look. And what happened was the accountant was on vacation. When they come back, they realized that Mr. Carver wrote these checks to himself. He cashed those. That was what he was indicted for. He paid restitution. That case was dismissed. Subsequently, Bluegrass learned after Miss
Let me
Gertie.
ask you something.
Yeah,
This indictment here does not involve those 3 checks. Is that
it
correct?
does, but I'll tell you this. It involves hundreds and hundreds of additional checks along with those checks.
Okay, well, what I'm gonna do.
Yeah.
Is just go ahead and enter a ruling on it, and those 3 checks would have to be introduced under other bad acts.
That's correct. We're not trying to recover any monies from those checks. But the way I understand Mr. Lanham's argument, if I have lived at my house and somebody's,
I've read
Yeah.
it, and I'm gonna overrule this motion
Got it.
on the thing. But I wanna make sure that those checks, now, those indictments were dismissed, is that correct?
that's correct.
Okay.
Yes.
Okay.
But the only thing Bluegrass would
Was
be.
there any written agreement on the dismissal of those checks?
No.
You know, technically, even if you do make restitution on some checks, it doesn't do away with the criminal activity that was there. I mean, but you can see that you did not desire to prosecute him on those 3 checks. Is that correct?
Of course.
Okay, now where are we in this case beside that?
Well,
Schedule
if we
trial.
want to do one more pre-trial, we can, or if Mr. Lanham wants trial date,
I
we
don't
can.
think there's gonna be any, I think we just need to go ahead and set a trial date. Don't you think so?
I think so. Judge, I would renew my motion. I think that the Supreme Court precedent.
I've already ruled on your motion
I
and you
understand.
preserved it for the
Preserved my
record.
motion.
Now, do you have expert witnesses that you'll need to line up, either one of you? So we have to put it out for a while, or do you think you've got access to everybody you need to?
I don't think we'll have to have them counts, and if we do, I'll give you back discovery on the CV things.
Yes, I mean, at this point, I don't know of any expert witnesses we would call,
Okay.
but again, we're a little bit in the dark as to what the Commonwealth's theory of the case is. So that may change.
Have you filed a motion for bill of particulars? Okay.
Maybe we need to do that and get that answer before we set a trial date.
Well,
If
we
you get
have
more
pretty
time.
much open discovery. There has been a reciprocal discovery order.
Yeah.
How many days will you need to provide him with which particular checks in the theory?
Well, we provided everything. We provided him with discovery from the previous case and this case. And I think all the checks were included in this case.
Okay, so
I
my
think all
ruling
the
today
discovery's been-
excluded those 3 checks or so that they made restitution of.
Yes,
So the theory of your case is the other checks, is that correct?
that's correct.
Okay,
Basically, the theory is he and Miss Gerke were taking money out of the account and then trying to replace that money before it was discovered.
okay. Okay, well, let's, what days are courts here? Well, that pretty much interrupts all 4 weeks there, doesn't it? What about the November? '26 and '27?
Thanksgiving, the 27th.
Okay, no, we don't want to do it on Thanksgiving.
We've got daily on the 1st.
Yeah, I see that. Yeah, that gets into December then. Okay, I guess we have to go over into January. Do you see anything with? What about October 6th and 7th?
For trial,
For trial, yeah.
Judge, that's not sufficient time, given the volume of discovery involved in this. I also have a trial, I think, on the 2nd.
What about the 13th and 14th?
I'm clear, whatever Mr. Lane wants to do.
I think that's possible.
Okay. See you then.
Do we have a deadline for Pretrial motions on the. Would you like to do that, please?
No, I don't want to do it on that day. We got tonight is a motion day for that, so if you have any pretrial motions or anything, relax. Edward Daly.
He is not here. I don't see him, Judge, but I think he has paid his restitution. He was going to have his restitution paid by this day.
Was Mr. Cross representing?
Yeah, I represent him, Your Honor.
Oh, you do? Do you know whether he's paid his restitution?
I have not been in touch with him, Your Honor.
Yeah, we've been told restitution paid just over the courthouse, so it's out of our, we'll withdraw the motion, you know. You know, look for.
I'll just add into a show cause docket next time, okay? You know. Then we're gonna start. We're gonna start, I want you to look up everybody that hadn't paid it. Starting to show cause. You do it in all the other counties. Christopher Guffey. Sentencing. That's the sentencing of Christopher Guffey. Are you Christopher Guffey?
Yes, sir.
This is, good morning. This is, 24 CR 0072. Mr. Guffey, were you born in 1976?
Yes, sir.
Last four digits, social security number 5843.
Yes, sir.
Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct.
Yes.
You were granted a pretrial diversion in this case, but it was voided and revoked on August 7th, 2023. Therefore, you are sentenced to 3 years to serve.
Your Honor, I believe we have an agreement with the Commonwealth to.
Well, I understand, but I don't know the facts, so I get all those people that get sick, I have to get a medical record, I've been really interested, this is my first time in that. But, he was released from jail to go to the heart of. Yes.
I don't know. Medical records formal.
So I don't know, he told me the other day, at heart surgery. Yeah, go back, the third. Do it for the people. And I got, paperwork there. Yeah, so that's the goal with the jail thing, something like that, that's all.
And yeah, he brought that this morning, Your Honor, some documents. He's been seeing a cardiologist. He's currently also enrolled in an IOP program.
IOP is not, does not impress me very much. He violated his pretrial diversion, was voided, and he's gonna go to jail. Okay, now, if you want to present before you get up here, wait till you get up here at the last minute. I'm not gonna do any of these last minute reprieves, you understand? Because every time somebody rushes me to do something, it ends up in Monroe County term as being gommed up. So you don't need to wait till the morning here and start pulling out medical records and expect me to look at it. So he's going to jail. Now, you can provide the medical records to Mr. Stockton, and to be fair with Mr. Stockton, so he'll have an opportunity to review the medical records. It's okay, and then we'll take some consideration. Thank you very much. Take him into custody. Christopher Hughes. Commonwealth versus Christopher Hughes. 24 CR 0047. You are Christopher Hughes. You were born in 1979.
Yes, sir.
Last four digits, social security number 3125.
Yes, sir.
And this is a request for a hardship license. What does the Commonwealth have to say about this?
I don't have anything to fix on for work.
What are the limitations on the document? Where do you work, Mr. Hughes?
Carter Gate.
Do they have locations outside of Casey County now?
It's just in double.
Yeah, that's in Casey County, isn't it? You just have one DU, you have two DUIs in the past?
The state that with the teachers of his employment, any county, any control orders, any school that be independent, any medical necessary, and he would have DUI.
It's for DUI classes too, at Polar.
Okay, I'll sign it. Don't violate this thing, you're getting on right on the edge of felony stuff, you understand what I'm saying?
Yes, sir.
When can he pick that up?
I'll take it for both you and you.
Do I need to sign it?
No.
Are any of the charters still involved in running the company?
Do what?
Are any of the charters, they sold the company, didn't
Yes, it's under new ownership.
they? Do any of the charters continue to manage it or did they?
I'm not sure on that. I know,
You don't send a
I
lot?
know they're making more, products than it was.
Yeah. Okay, thank you very much. Good luck.
You go across the hall. The both of you.
Megan Kennedy. Megan Kennedy.
Your Honor, he's in the restroom right now.
Mr. Cross here.
Right here.
All right, are you behind the thing there? This is J. Lee Longwell.
Yes.
Okay, J. Lee Longwell. I'm up versus J. Lee Longwell. 25 CR 0068. Are you J. Lee Longwell?
Yes, Your Honor.
You born in 2005?
Yes, Your Honor.
Last 4 digits of social security number 4845.
Yes, sir.
Here for a pretrial conference.
And there's also, Mr. Cross filed a motion for us.
Okay.
And we've been arguing about the law and he suggested one more pretrial conference.
Well, give me the facts as assumed.
Turn signal was not given leaving a parking lot. That was the basis for the stop.
Yeah.
And it was Junction Station. She pulled out, didn't give a turn signal. Officer Pendergrass, Deputy Pendergrass stopped her. I got to looking at the law and you look under the definition, it includes a parking lot. It's a roadway. So I think it's.
And I don't see.
I don't really want to prosecute it. I told Mr. Cross that I offered if you plead guilty to DUI, I'd dismiss the rest of the case, but he said he needed time to talk to her and that's the reason we suggested the pretrial.
If it's a bad stop, it's a bad stop. So give us one more date, Wood. We'll see where we are.
So what the court wants.
What's the other charge? Possession?
Possession.
What was the quantity?
It was.
Very small.
Wow.
Right. Just a minuscule thing, what Mr. Cross?
Meager.
Meager. What was it, meth?
Get my cases confused.
No, what was it?
Don't ask her what it was. My goodness, that means she knows it was there. Jeez, where'd you get it? Oh, my God.
So if we give us a negotiation day, we'll.
Negotiation day on October the 3rd, and you appear back here on October the 9th, okay?
Megan Kennedy's back here.
Megan Kennedy. Are you Megan Kennedy?
Yes, sir.
Good morning.
Good morning.
This is 25 CR 0046. You born in 1991.
Yes, sir.
What are the last 4 digits of your social security number?
1034.
1034?
Yes, sir.
Okay, you're here for sentencing today. If you had an opportunity to look at the pre-sentence investigation report by probation and parole,
Yes, sir.
is it substantially correct?
Yes, sir.
Okay. The recommendation was for 3 years, probated for 5 years. You're currently, are you still enrolled in Independence House?
Yes, sir, I complete on the 16th.
Okay, you remain in facility, complete the program, and you'll need to meet with the probation parole officer to give a report to see what the conditions are, okay?
Yes,
What are
sir.
the court costs in this case?
Okay.
$155, you pay it $30 a month, first payment starting 30 days from today.
Yes, sir.
Your Honor, and just one other thing with her is that after she leaves Liberty House,
It's Independence House. After I leave there, I'll go back to
Wait
drug
just a
court.
second.
she's going to drug court after that. And I just want to make sure that's on the record as far as supervision goes.
You want me to do a referral for drug court? It wasn't.
She's already she's already acted in drug court in Wayne County.
Okay, well, that'll be
And this would
fine.
just continue.
That'll be fine. Okay, thank you very much. Good luck to you. Jimmy Massengale. Commonwealth versus Jimmy Massengale, 25 CR 0045. Are you Jimmy Massengale? Good morning. Were you born in 1972?
Yes,
Last 4 digits of social security number 6814.
yes,
You're here today for sentencing. Have you had an opportunity to review the pre-sentence investigation report done by probation parole?
yes,
Is it substantially correct?
yes.
Okay. The Commonwealth recommended to 10 years, serve 120 days in jail with a balance probated for 5 years supervised. So that's what I will impose. How many days does the report say it has in?
Thank you.
88 days. Okay, you're in the custody of the jailer, and what the court costs?
155.
$155, and you start paying $30 a month, 30 days after you get out of jail, okay? Thank you very much.
Thank you.
Joseph McDermott. Joseph McDermott. Commonwealth versus Joseph McDermott. Are you Joseph McDermott?
Yes.
Good morning. Were you born in 1985?
Yes.
Last 4 digits, social security number 5733.
Yes.
You're here on 24 CR 0023 for a pretrial conference. What do we have here? You have a plea?
We have a plea here.
Is it a felony plea or a pretrial?
It is a felony.
Okay. A motion has been tendered, sir, that says you wish to enter a plea today. Is that correct? Move
Yes.
back over behind the podium.
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 24 CR 0023?
Yes.
Is your judgment compared today?
No.
What? Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes.
Review the evidence Commonwealth has against you. You believe you're fully informed about the case.
Yes.
Do you understand that you do not have to enter a guilty plea? You have certain rights that you have. Before I can accept a plea, I need to know that you fully understand those rights. I'm going to go down through the rights, and at the end, I'm going to ask you if you agree, if you understand. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand it, but enter your guilty plea today, you give up all those rights. You understand that? And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the recommendation of the Commonwealth and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes.
Now move to your left, sir. Mr. Hunley, what is the Commonwealth's recommendation?
Upon plea of guilty to theft by failure to make a required disposition of over $1,100, the defendant shall receive a sentence of 3 years probated for 5 years with the probation supervised. The defendant shall be permitted, the victim shall be permitted to have the vehicle in question towed from the defendant's real property within 30 days of the date of the entry of this plea, with the victim giving notice to the Commonwealth of the scheduled pickup date. The defendant's role in this part of it is that he shall leave the keys to the vehicle in the vehicle. The defendant shall pay restitution in the amount of $1,100 payable to the Clinton Circuit Court Clerk at the rate of $100 per month, with the first payment being due 30 days from the entry of this plea. Restitution is subject to a 5% clerk's fee. And lastly, the defendant shall have no contact with the victim and, of course, shall receive credit for time served.
Let me ask you about that a little bit. Something doesn't sit right exactly with me by leaving the car keys out there and the car disappears and then somebody wonders, well, I didn't get the car. Who got the car?
Your Honor, the car is gonna have to be towed.
Okay, so they're just leaving the keys in it so they have a key after the tow.
That's
Okay,
correct.
that assuages my problem. Is that, come back over? Is that your understanding of the recommendation?
Yes.
Are you pleading guilty because you did commit the charge and the indictment is amended?
Yes.
You're doing so of your own free will. Knowing your constitutional rights is still your desire to give up those rights and enter plea guilty and allow the court to fix your punishment. Is that correct?
Yes.
You understand that by entering guilty plea, future convictions can be enhanced and a persistent felony. You understand that? Is that your signature on the motion and offer?
Yes.
I accept the agreement order pre-sentence investigation report to meet under probation parole and schedule your sentencing for October the 9th. You meet with probation parole officer. Kevin Miller. Kevin Miller.
Your Honor, my understanding is he's incarcerated in Pickett County right now. I think he was picked up yesterday, the day before.
Well, you want to issue a warrant for him, Mr. Stockton?
Yes, Your Honor, I'm really incarcerated.
Okay. Issue a warrant for him. Seth Roberts. Counselor, when Mr. Miller is brought back up here, we need to make an entry in the record if he shows proof he was incarcerated, so he doesn't have an FTA on there for any future things, okay?
I'll make note of that.
Right now, it's a FTA.
Yes.
Are you Seth Roberts?
Yes, sir.
Good morning.
Morning.
This is 25 CR 0035. Mr. Roberts, when you born in 1993,
Correct.
last four digits, social security number 0026.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, he has a waived assignment, I think that, of course, Clayton County Jail. We had tendered an order to Mr. Rutherford to pay $1,000 by October 30th. We continue this generally.
Yes.
So if you got that order?
I have not gotten the order yet.
Well, we probably got it. What? Okay, put in October 31, we'll give you the order. So
Okay.
get that over. Just if we could read it, maybe in November,
What was your negotiation date in October?
October 3rd.
Do you want him there for October 3rd? It's too soon.
Too soon. Let's just set him for November. Pre-trial.
What's your negotiation day in November?
Don't know yet. That's too far.
He'll be back here on November 6th. And,
We'll know then if we need a negotiation.
okay, well, we don't have it set yet, so you keep in contact with your attorney. And when he finds out what the negotiation day, that's gonna be a continued requirement of your bond for you to take the initiative and find out what the negotiation day is. In November. Okay, thank you very much.
Okay, thank you.
Steve Stearns. Commonwealth versus Steve Stearns, 25 CR 0063. Are you Steve Stearns?
Yes, sir.
Good morning. You were born in 1987.
Yes,
last four digits, social security number 7231.
yes, sir.
We're here for a pretrial conference and a motion to revoke bond. You moved to your left here. Wasn't Commonwealth have to say.
Your Honor, on a motion to revoke bond, Mr. Stearns, our position is he's violating his curfew because August 25th, he was stopped by Deputy Pendergrass at the junction of Highway 734 and Mount Union Road. He was armed at that time, and then on August 27th at 1 a.m.,
What do you mean he was armed?
well, he had
Okay, wait just a second.
he had a pistol with him. And then he also had
Okay,
a
wait
pistol.
just a second. You be quiet while this is going. You better listen to what's going on here. You understand? And I'll give you an opportunity to talk to your attorney.
Okay.
Go ahead.
And then 2 days later, he was stopped by Deputy Pendergrass again near Junction Station at 1 a.m. And he was armed again with a 9mm pistol. So I don't know if the conditions of his bond, I don't think prevented him from being armed. I don't know. But he was definitely out past the curfew.
Your Honor, for his job, he does odd jobs for Sarah McCorder, and I think it's at different times during the day. She has some health issues.
He's in the hospital right now, that's fine.
Well, be quiet. You be quiet. Okay.
So she has some health conditions, so sometimes she'll ask him to come later in the day and do some work for her. I think it's primarily mechanical type work.
At 1 o'clock in the morning? You need to step aside and talk to him a little bit. What's he going to?
Okay. He says he's just trying to accommodate her schedule.
I don't. What's the underlying charge?
He's charged with setting a booby trap device
Okay,
and
you have violated the terms of your bond. I'm gonna revoke the bond. And we need to set a trial in this case. Okay? We're gonna give it a speedy trial here. Can you be ready for trial in a couple of weeks on this thing? Because the 29th or 30th?
well, I'm not well, 30th. All right, so do 30.
I can do the 29th.
Set the 29th. Okay, take him into custody. Joshua Talent. Commonwealth versus Joshua Talent, 25 CR 0020. Joshua Talent.
Yes, sir.
Good morning. You born in 1989. Yes, sir. Last four digits, social security number 3393.
Yes, sir.
Mr. Cross, you step over this way. I can have center stage for a minute, please. We're here for a pretrial conference. What's the Commonwealth have to say? Tell me about what the charge is.
It's a possession of methamphetamine and desperation hearing. And Commissioner Talent, authorized for the purchase of methamphetamine.
Okay, I got you.
So
A motion has been tendered that says you wish to enter a plea here today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0028?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
We had plenty of time to discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
Have you reviewed the Commonwealth's evidence and you believe you're fully informed about the case?
Yes, sir.
You understand you don't have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. Before I can accept the plea, I need to know you understand those rights.
I do, sir.
The right not to testify against yourself, no one can know the same thing, right to speak trial, but jury right to represent the counsel, jury trial, the right to confront and prox and no witness call testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you guilty of charge against you. You understand that by entering guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply my own sense to provide law. I don't have to accept the recommendation. Prior to accepting, this is a misdemeanor charge, is that correct?
Yes, it is.
Would you, go ahead and go with the recommendation?
Upon a plea of guilty to possession of drug paraphernalia, the defendant shall receive a sentence of 90 days, probated for 6 months, with the probation unsupervised. The defendant shall pay a $250 fine and cost and have no further violations of the law. The defendant agrees to have any evidence in this case disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of Commonwealth's recommendation?
I do, sir.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes, sir.
Okay. You're doing so of your own free will.
Yes, sir.
When your constitutional rights explained to you, you still desire to proceed in with plea and allow the court to fix your punishment.
I do,
Is that
sir.
right? Is that your signature on the document?
Yes, sir.
Okay, well, I will go ahead and accept the plea and sign the judgment today. It's supervised. Unsupervised. I'm a little concerned about the length of the probationary period just being 90 days, tell you the truth.
6 months is the probation.
Yeah,
90-day sentence.
90 days since for 6 months, okay. Okay. You get a copy of Jay. Nathan Stockton. Nathan Stockton. Are you Nathan Stockton?
Yes, sir.
Good morning.
Come on.
This is 25 CR 0022 and 25 CR 0036. Mr. Stockton, you were born in 1991.
Yes,
Last 4 digits, social security number 5920.
yes.
Okay, what does the Commonwealth have to say on these
We need
people?
to trial Adam 25 CR 22.
What is that charge?
It's theft of possession. Those are making the same thing.
So you elected that charge.
Yes, that's the oldest case. I think Mr. Stockton is trying to make some arrangements on restitution, so if you want to set it out in November, I don't have any case. I'll give you an opportunity to file it.
Yeah, that's correct.
November 21st.
That's,
Okay?
that's fine with me, though.
That works for me as well.
Okay. Yeah, we have, Kentucky State Reformatory scheduled to be on at this time for a motion for an appeal bond.
Judge, I've been into a vet, he's in the hospital.
Okay, he's in the hospital, so we'll pass over that. Pulaski County, are you on there? We'll go to Russell County. Russell County, you're scheduled for now. If you turn your, there you go. We'll call Winter Brown.
She's on here, Your Honor.
Pardon?
Winter Brown's not in our facility. She got out.
No, she's been moved to the hospital.
She has been released from the facility as well.
Because she's gone to the hospital, correct?
Yeah, she was out on bond, but she's currently in the hospital.
What's last one?
Y'all are picking up on the microphone.
Can you hear me, Judge?
Yeah, I can hear you. I'm looking at something else about her right now. And we'll get to your next part in just a second. Thank you.
Okay.
Have you seen this letter, Mr. Stockton?
No. Explain.
Medical records.
No, I understand.
Your staff, look at them, we'll pass her over. Brandon Hall, there in Russell County, Brandon Hall. Are you Brandon Hall?
Yes, sir.
Good morning, this is 25 CR 0039. Mr. Hall, were you born in 1982?
Yes, sir.
Last four digits, social security number 3773.
Yes, sir.
Sentencing, have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
No.
On plea of guilty to trafficking and controlled substance, first degree, second offense, he shall receive a sentence of 12 years to serve. Okay, I'm gonna waive any court costs considering the length of the sentence.
Thank you.
Thank you very much. Matthew May is next. Matthew May. Are you Matthew May?
Yes, sir.
Good morning. This is 25 CR 0048. Mr. May, were you born in 1978?
87.
Okay, I had transposed in 1987. The last four digits, social security number 0653.
Yes, sir.
I'm here for sentencing today. Do you look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty to possession of firearm by convicted felon, he shall receive a sentence of 3 years. On plea of guilty to possession of controlled substance, 3 years, 3 years. Sentences, however, shall run concurrently, total of 3 years to serve. Years shall run consecutively to Clinton indictment 21 CR 00114 and defendant agrees to stipulate on revocation and Clinton indictment 21 CR 00114. Considering the length of sentence, I'm going to waive court costs.
Thank you.
Okay, thank you very much. Kaylee Smith. Swift, excuse me. Kaylee Swift. Are you Kaylee Swift?
Yes,
Were you born in 2001?
yes,
Last four digits, social security number 2547.
yes.
You're here today on 24 CR 0017 for pretrial diversion revocation. Represented by Mr. Whittenberg. What's the Commonwealth have to say?
Your Honor, she's on for pre-trial version verification, and she also did basic things, a new felon in possession. I'd ask you to set for October 3rd at 1 o'clock, maybe we was October 1st.
That other case is not on my docket.
Probably you'll see it today.
Okay. We'll set a negotiation date for you, ma'am, for October the 3rd, and the next court date, October the 9th. Both of them are conditioned to your bond.
Thank you, Your Honor.
Russell, thank you. Russell County, do you have anybody else that might not be on the docket that's scheduled to be here? Is that it for you? I guess it is. So Russell County, you're excused. Russell County, is there an officer there somewhere?
Yeah,
You have anybody? Do you have anybody else scheduled there for us today that I haven't called? Is April Russell there? Is April Russell in your facility?
Yes, she is.
Well, we had her in the wrong facility. Bring April Russell around, please.
Okay, give me just a second.
Okay. Here you go.
All right, Your Honor, here's April.
Commonwealth versus April Russell, 25 CR 0069. You are April Russell,
yes, Your Honor.
born in 1990.
Yes,
Last 4 digits social security number 0500.
yes.
I've just appointed the Office of Public Advocacy to represent you. You're
Okay.
here today for arraignment. You have a right to remain silent. The attorney is here present in the courtroom. The grand jury of Clinton County has returned an indictment charging possession of controlled substance and first-degree methamphetamine. Do you understand what that charge is?
Yes,
Counselor, you acknowledge receipt of the indictment. The identity of your client, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I just signed a reciprocal discovery order, Ms. Russell, in order to guarantee that the Commonwealth turns over to you the evidence they have in preparation of your case. We'll order you to be present on October the 3rd for a negotiation day, and October the 9th for your next court date. Both of those are conditions of your bond.
Okay.
Okay?
I'll see you soon.
Okay, that concludes, I don't think we have anybody else in Russell County that we're aware of.
That's all we have, sir.
Okay, you're excused. Thank you for your cooperation.
Thanks, sir.
Wayne County is on the line. They are. Wayne County, will you turn your camera on? There you are. Commonwealth versus Amanda Jewell. Y'all need to turn your microphone on, please. Wayne County. Should be a little red dot there that looks like an old time marker. There you got it.
Yeah.
Okay, Commonwealth versus Amanda Sewell. Are you Amanda Sewell?
Jewel,
Jewel, Amanda Jewell.
yes, Your Honor.
You were born in 1988.
Yes,
Last 4 digits social security number 5232.
yes.
We're here today on a probation revocation, in 21 CR 0075 and 22 CR 0052. What's the Commonwealth have to say?
Your Honor, she has a 10-year sentence. She's got 2.5 years on her sentence.
Okay, wait a second. You, ladies in the background, y'all need to quieten down a little bit. Keep in mind, okay? Go ahead.
7.5 years on traffic and controlled substance first for a total of 10. She was placed in the Clinton County Drug Court. She graduated. Subsequent to that, she had a positive meth on 12/2/25. And then she had a positive in July of this year, and she denied use, and it was sent to the lab, and it was confirmed she had meth. So get to the point, we don't know what to do, other than ask for revocation.
Yeah, Your Honor, after she had completed drug court, her mother passed away and she had a difficult time. She just asked that the Commonwealth consider rehabilitation for her, long-term rehab.
She was thrown out of drug court or
No, she graduated.
finished her.
So she can comply when she wants to.
How many days has she been in now?
I'm not sure.
How many days have you been in?
30 days as of today or tomorrow.
I'm gonna give you a 90-day sanction, and then I want you to find a rehab to put this lady in. I'm not gonna send you up for good, okay? I'm gonna give you another chance, but this is it.
Thank you, Your Honor.
You serve an additional 60 days. We'll give you the 30 days, you got 60 days, and your attorney will help find a placement in a long-term rehab for you. Hopefully you can turn your life around, okay?
Thank you, Your Honor.
Okay.
Thank you.
Laura Jones. Are you Laura Jones?
Yes.
Good morning. This is 25 CR 0057. You born in 1991, Miss Jones?
Yes.
Last four digits, social security number is 7626.
Yes, sir.
On a probation, what's the Commonwealth have to say?
Your Honor, she's got a 2-year sentence on possession of a controlled substance. She told Mr. Payne in around the end of July, 1st of August, that she was employed in Tyson. He called out there. She wasn't employed. He had her set up for the SSC. She didn't meet with the SSC, and then she didn't report in August, and he listed her as not responding.
You know, she also would like to ask for a rehab or drug court.
Well, she's a liar. She's lied to us. You know, at least the other people have fessed up to what they've done. I mean, we can't allow people just to go around and lie to probation parole officers, say they're employed. I mean, your jobs are hard enough. Not complying.
Can I speak?
Yeah, if you want to.
On my job, I had a job at Tyson, was supposed to went for my interview and stuff, but couldn't get a ride. And then with my home placement, I was staying with my sister, and me and her had got into an argument and was currently homeless at the time. I'd actually checked in with probation and parole and let them know that I didn't have a ride there or whatever. But it wasn't like
they're saying that that's not true. Now, if I were to give you a sanction of some sort, where would you live if you got out?
With my uncle,
What's his name?
Thomas Bagwell.
Is that in Wayne County or where is that?
No, that's in Clinton County.
I think she probably needs to be for long-term treatment.
Okay, well, I'm gonna revoke your probation, and then we'll look at shock probation. So you need to try to line up some employment. Be no more than 30 days, I guess, before you take a look at that.
Just let me know.
Counselor, why don't you let's take a look at this on November the 6th, or if you can get an agreed order before then. All you gotta do is just tell the truth to these people and cooperate with them the least bit, and you could be out by Thanksgiving maybe, you know?
Yes, sir.
She will be eligible for the release on.
Yeah, so I'm gonna take a look at Our rule day is October the 9th, and so you could be eligible by then for shock
Okay.
probation.
Yeah, I think it's just a few days after the,
It won't be until 11.
Yeah. You know, I could do it by agreed order after that. If not, we'll schedule it for November the 6th. For review, if you want to file a motion for shock probation by then. But if the Commonwealth could agree anything after, you say you're 11, you become eligible on October the 11th. So if you want to do an agreed order, so you need to find her a placement where she's gonna live, have somebody investigate it and see if she the question is, you want to be free or not? And the only answer to that is in your heart and in your hands, you understand? Because I will send you the penitentiary if you lie and won't comply, you understand?
I won't, sir.
Okay, they'll be in contact with you.
Thank you.
Nancy Raines.
Yes,
Are you Nancy Raines?
I am.
You born in 2001?
Yes,
Last four digits of your social security were 0300, is that correct?
yes.
You're on 22 CR 0067 for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yeah, I think so.
Well, that's the paperwork your attorney went over with you to see about what your background is. So counselor, did you go over that with her?
Plea, and start attorney.
Is Trey Wilkerson your attorney?
No, Corey is, and I have not talked to him or nothing.
Ah,
I apologize, Your Honor.
okay, well, we'll have to wait and let him go over this with you.
Yeah, I'll do that today. I'll stop by.
He'll come see you today.
Okay.
Okay, thank you very much. Mary Russell. Mary Russell.
She's not in here. Hang on.
Okay. Hang on.
Hey, Laura.
New intercom system at Wayne County Jail.
They're asking for some girl in here. They're asking for some report. It's not in here. Strict 13. They said they didn't have a Mary Russell here. They have an April Russell, but Mary Russell's in Russell County.
It's where?
Russell County.
Okay, thank you very much. Wayne County's excused.
Yes. Continue on.
Let's go ahead and continue to win. What's it?
Yeah, I was, she just appointed another attorney. I have co-counsel DPA on this case, so.
He's not involved in the case. Are you co-counsel?
That's my understanding, yes.
Well, you understand more than I do. Well, there's no reason to set up a negotiation day on a charge like that, is there, Mr. Stockton?
No, I just asked them whatever they want to.
Put her on for October the 9th, and then we can know where we are after that, okay? Here on October the 9th. Mary Russell, that's 25 CR 0067. They say she's in the Russell County Jail. Okay, let's go to the Clinton County Jail. Clinton County Jail. Clinton County, are you ready? I'm waiting. Clinton County, are you ready? 12 minutes early. Okay, let's go off the record for 12 minutes. Could you call Pulaski?
I'm sending an email right now.
Yes, Your Honor, Clinton County's here.
Going back on the record. Michael, Clinton County Jail, Michael Ash. Commonwealth versus Michael Ash.
Your Honor, they're currently grabbing Mr. Ash from the cell. I will not put me in. You just, I ain't gonna. You put me up, yeah.
Okay, we have Michael Ash, Austin Edwards, Mitchell Finley, Dawson Jarvis, Nicholas Kuba, Jameson Wallace, and Robert Wright. Okay. Commonwealth versus Michael Ash. Are you Michael Ash?
Yes, sir.
You born in 1960?
Yes, sir.
It's 4 digits, social security number 0684. We're on 25 CR 0037. What's the Commonwealth have to say on a pretrial diversion revocation?
Got a 3-year sentence on possession.
Come up before we get you on the camera for a second. Go ahead, Mr. Stockton.
And,
Say what you said previously.
he has a 3-year sentence on possession of controlled substance first degree. He was directed by probation to parole to report on June the 26th. He did not. The next thing they found out was he had a misdemeanor arrest in Pickett County on July the 4th, and he's never reported in this case since then.
Y'all will stipulate. Yeah. Stipulate, I will revoke the pretrial diversion order pre-sentence investigation report to be done and schedule sentencing on October the 9th. Okay. Okay, Austin Edwards. Mr. Ash, the probation parole people will be coming down to talk to you pretty soon, okay?
Okay. I'm not sure what the sentence was. I couldn't hear you.
You weren't sentenced today. You'll be sentenced on October the 9th. They'll be down to talk to you about it, okay?
Okay.
Thank you. Austin Edwards.
Yes, sir. He's right here.
Good morning, Mr. Edwards. Were you born in 1999?
Yes, sir.
Last 4 digits, social security number 5883.
Yes.
22 CR 0071, a pretrial diversion revocation to represent Mr. Cross. Mr. Stockton, you want to come forward?
Yes, Your Honor. Mr. Edwards has a motion to revoke on for today. He also has another possession case going to the grand jury today. So I'd ask if we get a negotiation date, see if we can wrap everything up.
Okay, negotiation date will be set for October 3rd at 9 a.m.
Bill at 1 o'clock.
At 1 o'clock,
1
actually,
o'clock.
1 o'clock,
October 3rd,
October the 3rd at 1 o'clock, the next court appearance, October 9th, both of them condition of bond. And he's down here in the jail. If you want him up here, you can do a transfer order.
Austin, I'll be down to see you first of the week, okay?
Okay, thank you. Your Honor, I apologize to you and the court for the last time I was here.
Mitchell Finley, thank you.
Yeah.
Commonwealth versus Mitchell Finley, 25 CR 003, R. Mitchell Finley, born in 1966, and the last 4 digits of your social security number 0720. Is that correct?
Yes.
What do we have here, Mr. Ross?
Misdemeanor plea, Your Honor.
Mr. Finley, a motion been tendered says you wish to enter guilty plea today. Is that correct?
Yes.
Currently under the influence of drugs or alcohol?
No.
Is the plea freely and voluntarily given? Are you, is this plea freely and voluntarily given?
Yeah. Yeah.
Are you the same person we identified in 25 CR 003? Is that you?
Yeah.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
You viewed all the evidence the Commonwealth has against you, feel like you're fully informed about your case. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself, no one to make you say anything, right to speed trial by jury, right to be represented by counsel at your jury trial. The right to produce evidence, the right to confront and cross-examine all witnesses called to testify against you, the right to call witnesses in your favor, and have process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, the right to apply the Commonwealth to prove beyond a reasonable doubt to be guilty charged against you. Understand that by entering a guilty plea, that you give up those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentences provided by law. In the event I don't accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Upon plea of guilty to the offense of unlawful imprisonment in the second degree, 2 counts, the defendant shall receive a sentence of 12 months on each count to run concurrently for a total of 12 months, probated for 2 years with the probation unsupervised. The defendant shall receive credit for time served, and he shall pay a fine of $250 and costs and have no violations of the law.
Is that what you agreed to, Mr. Finley?
Yes.
What are the total fine and court costs?
$405.
He's gonna be released pretty soon? Okay, you'll need to start paying the court costs, $405. $405. I'll let you pay that at $30 a month, starting 30 days from today, okay? And they'll have the release papers up there for you today. Is it to be supervised?
No, no.
Okay, well, the papers will get up there today and you can contact your attorney to, if you have any details, okay? Thank
If
you.
you need to require his signature, you're on.
Yeah, let me hand that up here. So you are agreeing to enter this plea, correct? Is that what you agreed to?
Yes.
Is that your signature on there, sir? Is that your
Yes.
signature?
Yes.
Okay, well, I'll accept it, enter the misdemeanor judgment today. Dawson Jarvis. Pulaski County will be with you in just 3 more people. Commonwealth versus Dawson Jarvis. 25 CR 009, 25 CR 0016. Are you Dawson Jarvis?
Yes.
You born in 2001?
Yes.
Last 4 digits, social security number 7215.
Yes.
We're here on a pretrial diversion revocation. What's the Commonwealth have to say?
Your Honor, he has 2 cases. He had 2.5 years on each. Their possession of controlled substance, first degree, run consecutively for 5 years. He was placed in the Clinton County Specialty Court. He was terminated from the specialty court because he had 4 positive tests of one pill, and then he had, when they took him into custody, the sheriff found that same pill on him. So, that's the reason we're asking for the diversion revocation.
Stipulate. Okay, I'll revoke the pretrial diversion, order pre-sentence investigation report to be done, having to appear on October the 9th for sentencing. And we'll consider anything about that. Your attorney will be over to talk to you, Mr. Jarvis, okay? Nicholas Kuba for sentencing. Are you Nicholas Kuba?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits, social security number 8854.
Yes, sir.
Here for sentencing, you get an opportunity to look at pre-sentence investigation report by probation and parole.
Yes, sir.
Is it substantially correct?
Yes.
Any reason why this gentleman should not be sentenced today?
No, Your Honor.
On pleading guilty to tampering with physical evidence, he received a sentence of 5 years. On pleading guilty to possession of controlled substance, first degree, shall receive 3 years. The 5 and the 3 years shall run consecutively for a total of 8 years. Probated for 5 years, the 8 years shall run consecutively to Russell indictment 24 CR 0078. And is that's time to serve, correct, Mr. Stockton?
Yeah. No, it's probate. Yeah, he's serving this time. You got credit.
Okay. So I will, what are the court costs? I combined the court costs in two cases.
155.
Court cost is $155. Within 30 days of your release, you pay $50 and $50 a month, so the $155 is paid in full.
Your Honor, he's going into long-term rehab, so if we could maybe try to schedule sometime after
Well,
that.
I'll let you wait till after the long-term rehab to pay your court costs.
I am placing, since he has been sentenced now, I'm placing a detainer on his Russell County case. The Russell County Court would like them to come in front of him to answer to these charges. Then they will look at treatment for the Russell County case also. So he'll have to satisfy Russell County before he can go to treatment.
Okay, that'll be
So
fine.
here's my question, is do I need to release you because Clint?
Not until we get a bed date.
Okay.
What?
Yeah.
Okay, your attorney will be able to explain this to you, sir, okay?
All right, thank you.
Jameson Wallace. Commonwealth versus Jameson Wallace.
Hey, Jameson. County jail.
Are you Jameson Wallace?
Yes, sir.
You are in 2003.
Yes, sir.
Four digit social security number 1655.
Okay. Yes, sir.
Here in 23 CR 00013 for a pretrial diversion revocation. What's the Commonwealth?
Your Honor, first of all, I formally represented Mr. Wallace. I have not been retained to handle this and was first told I would be, and then I've not been. So I did advise Mr. Wallace last week I had not been retained to assist him in this.
What do you have in this?
He's got 3 problems, Your Honor. In March of this year, Hannah Morgan took out an EPO or against him or a warrant of arrest because he allegedly hit her with a bottle and punched her 3 or 4 times. Then Tahani Davidson, I believe, who is here, took out an arrest warrant on him where he was harassing her. And now he's got a new felony arrest on theft of identity August 8th.
Okay, what we'll need to do is, since his attorney waited this morning to withdraw, Mr. Jameson, your attorney withdrew. You'll either have to sign an affidavit as to whether you can afford an attorney or have a private attorney and be back here in court on October the 9th, okay?
Yes, sir.
Robert Wright.
Okay.
Robert Wright.
Yes, sir. He's coming right here. Yes, sir.
Are you Robert Wright?
Yes, Your Honor.
Okay, were you born in 1981?
Yes, sir.
Last 4 digits, social security number 6136.
Yes, Your Honor.
You're on 20 CR 0070 for a probation revocation. You represent the Office of Public Advocacy. What does the Commonwealth have to say?
Your Honor, he's got a 3-year sentence in 20 CR 70, but we've got a new felony he needs to be arraigned on. So if we, at 25 CR 72, if we can set him for negotiation on October the 3rd.
Hold on him. put a hold on him since we know he's been indicted.
Yeah.
And on October the 3rd at 1 p.m. for negotiation, next court date, October the 9th. They're gonna try to wrap all your stuff up into one situation, so your attorney will come over on October the 3rd. They'll transport you for negotiations, okay?
Yes, Your Honor.
Thank you. Okay, that concludes. I don't think there's anybody else in Clinton County that we're scheduled to have. Okay, Clinton County's excused. Let's go to Pulaski County. Pulaski County, Commonwealth versus Eddie K. Jarvis, which is 25 CR 0064. Mr. Bertram's here. Mr. Jarvis, you were born in 1947. Last four digits, social security number 7422. Is that correct? Go ahead.
Your Honor, we need another pretrial conference date on October the 9th in this case. The reason for that is there have been some issues associated with Mr. Jarvis's mental capacity.
Okay, October the 3rd is a negotiation day if you need it. And October 9th is the next court date.
I think October 9th is, we've tried to negotiate for until we resolve these mental capacity
Okay,
issues.
October the 9th, do you need an order or something, or what are you gonna do?
We're probably going to get an order. There's been a psychological evaluation.
Well, I don't want to go into the detail of it, because we broadcast, okay?
Okay.
So y'all keep the order on that. Okay.
Thank you.
Your attorney will be up to see you, Mr. Jarvis.
Oh, Judge,
Next is Michael Turner.
Judge.
Michael Taylor. Michael Taylor. Michael Taylor. Bring Michael Taylor around, please.
Yeah, I know he goes.
Thank you. Commonwealth versus Michael Taylor, 24 CR 002. Are you Michael Taylor?
Yes, I am.
You were born in 1984.
Yes.
Last four digits, social security number 286. We're here on 240002. What's the Commonwealth have to say?
I was going to schedule a conference here and then Mr. Poindexter introduced me.
Why don't you come on up before we get you on camera? Mr. Poindexter, go over on the side. Mr. Poindexter, you're replacing Mr. Foss in this
I am,
case?
Your Honor.
Okay.
I think Mr. Taylor's been in jail about 630 days. And we had filed a motion for a competency hearing schedule it. And then Mr. Poindexter, his appearance, wanted to know if there's going to be a competency hearing today. And I said, no, I'm just trying to get it scheduled.
Has he been evaluated yet?
Yeah, yes, sir. Yes, he has.
Then let's schedule a competency hearing then on the end of the docket.
Well, we have trouble with the doctor in this case, and we just do it by agreed order, just get some dates from the doctor.
Yeah, we can do that.
Okay. All right. That's fine, man.
Preferably be one of our rule days, okay? Mr. Stockton? Preferably be on one of our rule days you can schedule.
We might have some dates that can get those. I don't know how long this is.
Well, y'all just go ahead and do that and we can schedule it because those dates you have might not be good now.
Okay.
See what I'm saying?
Give you that much.
Yeah, Mr. Taylor, your attorney will be up to see you. Okay. Okay, does that conclude the criminal docket? Ms. Thompson, is that concludes the criminal docket? We'll come back in at 1 o'clock. Is it correct? 1 o'clock. So let's go off the record.
We submitted a great order in that case.
electronically.
Yes.
Smith versus Smith.
Great order submitted electronically in that case, Judge.
Okay. Cabinet versus East.
Judge, this is a motion. I guess we've submitted the order to transfer venue to Pulaski County. But just
Sounds
so-
like the proper place.
It sounds like the proper place for you. So Pulaski County.
Commonwealth versus Young.
Having a great order submitted electronically in that case, Judge.
Cabinet versus Davidson.
Judge, in this case, it's to establish child support. So I need to put Stephanie under oath, so I can get a little
You raise your
testimony.
right hand, you swear the testimony about to give truth, whole truth, and nothing but the truth.
I do.
State your name.
Stephanie Witham,
By whom are you employed?
Clinton County Child Support,
And what is your position?
caseworker.
Are you familiar with the case we're hearing today involving Hosapple versus Davidson?
Yes,
Okay, and are you the caseworker in that case?
yes,
Okay, have you ran the figures through the Kentucky Child Support guidelines as far as what the child support amount should be?
yes.
And what does that come out to?
$312 per month.
Okay, and how many children are involved?
Two children.
Okay, and was the non-custodial parent served?
Yes, May 22nd.
And have you heard any response from the non-custodial parent?
No,
Okay.
Okay, you want to submit to the order?
Yes, we have, Judge.
Carver versus Carver.
Judge, in this case, non-custodial parent owes $1,592, and we're asking that Mr. Carver pay $750 by October the 8th.
Sounds reasonable. Submit to order. Willis versus Evans.
Have an agreed order in that case, Judge.
Cornwell versus Carlton.
Okay, this will be a motion to establish Ms. Stephanie to testify.
Still under oath.
Okay.
sounds good.
Okay, state your name.
Stephanie Witham,
Okay, by whom are you employed?
Clinton County Child Support.
Okay, are you the caseworker in Cornwell versus Carlton?
Yes,
Okay, and was a complaint filed in this case?
yes,
Okay, and was the non-custodial parent served?
yes, June the 3rd.
Have you heard any response?
No,
Okay, have you ran the figures that you've been provided through the Kentucky Child Support guidelines?
yes, asking him to pay $316 per month,
Okay, and when would you ask that to begin?
September 1st.
Okay,
I think that's it.
submit in
Judge.
order. Is that it?
That's it, Your Honor. Thank you.
No problem. Let's go off the record, so the docket will start to one. Tires and Twin Oaks Investment Advisors versus Del Holla Charcoal.
Thank you, Judge. This is Nick Wallingford.
Okay, you asked for me to sign an order denying the motion to alter, amend, or vacate.
Yes, Judge. if
Mr.
you-
Wallace was provided 10 days to file a brief and has filed no response.
Correct. We'll stand on the motion, Your Honor.
Okay, I'll sign the order denying defendant's motion to alter, amend, or vacate.
Thank you, Judge.
Thank you. You submit that electronically?
We will, Your Honor.
North American Tax Solutions versus Lynn Wade and others.
Good afternoon, Your Honor.
Hello.
This is my motion on behalf of Rhonda and Dustin Angel. Terry Angel was the purchaser of this piece of property at a master commissioner sale years and years ago. It has come to the attention, Mr. Angel passed away years ago, leaving his wife Rhonda and son Dustin as his heirs. There was never a deed made from the master commissioner that they are aware of. There's nothing recorded to that effect that anybody's been able to find. I spoke with the master commissioner about it and filed this motion asking the court for an order that a deed be made to Rhonda Angel and Dustin Angel as joint owners of this property that was purchased by Terry.
I believe that's different from Charlie, the property you purchased. It was a different sale. So I don't think it affects you, or do you understand that? Is that correct? I believe so. So I have no objection.
Well, what I asked you to prepare these and submit it to the master commissioner, and I think the proper way for the source of title to be is that the decedent bought the property at a master commissioner sale and put the date on that and say that, and then he passed away on such and so as evidence by affidavit of descent or will or whatever, and that's where they acquired their interest.
Yes, Your Honor.
I think that way to have a complete change.
I think that would be the best way to do it. An affidavit of descent is filed.
Rather than just give one from master commissioner directly to his heirs, I think there needs to be an explanatory thing.
Sure, and I can do all that, prepare that and explain it. The affidavit of
You'll
descent's been
submit
filed
that.
for several
You
years.
submit that in an order, and I'll direct the master commissioner to sign it, okay?
Very well, Judge.
Okay.
Yeah.
Carter, Brandy Carter versus Donald Carter.
Judge, this is Jason Kinser. Thank you for allowing me to appear by Zoom.
Can you turn your camera on?
I can, but I'm just warning you, I'm not in courtroom attire, if that's okay, Judge.
Yeah, well, are you clothed? That's all right. You're clothed. Should have asked you that before you flipped it
You
on.
may be clad in Lincoln green, as they say.
Yeah. Okay.
Your Honor, we made a lot of progress. We had an informal mediation and we're passing this to see if we can't narrow the issues where you and your law clerk don't have too much to.
I don't have a law clerk.
Well, you have a.
I have a staff attorney.
Staff attorney, whatever.
Yeah.
You and your staff attorney.
I call you a junior associate of your solo practice with him.
Well, that's fine. We'll,
okay, so you want to pass both parties?
Judge,
yes. Go ahead.
And Judge, I saw it just came through on CourtNet that the Commonwealth has filed a motion concerning child support. I don't represent him on that. I only represent him on these visitation issues. So I don't know if you want me to, if I have to appear for his issue on child support, if this obligates me to that, or if I can just do what I was retained for.
It wasn't on the child support docket for today.
it was, wasn't there? Maybe not.
It was just,
okay.
It was just filed today.
Okay, well, you can discuss that to him to see if you want to represent him or not. I don't know.
I just didn't know if you wanted to, if my appearance was mandatory regarding those issues.
Well, I don't usually require people to represent people in things that they didn't hire up to do and don't want to do, but now if you want me to make an exception in this case, if it would make your conscience feel better, I can't order you to do that. And any other
No,
things
Your Honor,
about appearing.
I just didn't want my name to be on the record and me not appear when his name was called, as long as I am clear on your.
His name will not be called on any child. We finished the child support docket, so you can negotiate with him to see if he wants to expand your representation, I guess, okay?
Thank you, Your Honor.
Now, you want to put a date for it to review this thing? You guys want to put a date?
Your Honor, we're both moving on it. I don't think that's necessary.
November the 6th, knowing the nature of the way things operate sometimes, November the 6th.
You know me well.
Thank you, Judge. That sounds good. That's all I have, if I can be excused.
Sure, absolutely.
Thank you, Judge.
Dickin versus Dickin. Okay.
It's our motion, Your Honor. I think the motion largely speaks for itself. I note Mr. Bruce does not have counsel today. These parties were divorced several years ago. They got two boys, teenage boys, and they're good boys. But they decided, they went through a couple of years or more, they didn't want to go up to her house, and she never did raise an issue with that. And now they decide they don't want to be with Mr. Dickin here. And they're not really thriving. One of them's already quit football and been suspended in school suspension. And it's just, they don't have any discipline up there. And what I would propose we do today, Your Honor, is this. Number one, tell these folks they need to go back to the order where it's basically 50-50. They can figure out how to divide the time. Number two, if Ms. Bruce wants to file something to modify, give her a little time to do that. I've got a draft order that says by October 1st, so we can get it heard at the next motion day. And number three, if she does file something, let there be a friend of the court appointed to talk to these boys. And in the meantime, if something is filed, and this is the trouble.
Where are the boys now?
They're sitting outside in the hall.
Yeah, how old are they?
15 and 13.
Okay, but they're living with you now?
No, they're with her.
Living with you now. And you can move over that way,
Yes.
Mr. Cross.
And
Move over that way, Mr. Cross.
Yes,
want to
I
talk to
will.
her for a
I
second.
wanted.
Move over that way. Okay,
I
I want to talk to her for a second.
Okay, that's.
Okay, thank you very much. Now, you don't have counsel here today. Are you going to obtain an attorney to represent you in this thing?
I have tried to get one, but such short notice, I've not been able to come up with one.
Okay, well, there is a shortage of attorneys that want to take cases that involve any kind of visitation and that sort of thing around. Mr. Little on occasion Mr. Little, are you interested in getting involved in this?
No, I wouldn't take that case.
You can't take one more?
Mr. Ramsey's here. Mr. Ramsey.
Mr. Ramsey, do you take any cases like that?
No, Your Honor, not anymore.
There you go. That just validates what you're saying, so.
I'm reminded of what Eddie
But
Lovett
don't
said.
tell me any stories here. I didn't want to trigger you.
Sorry.
Okay, well, here's the deal. These boys are not gonna be making the decision on what they're doing. And aren't gonna be putting y'all in a situation to try to force them to do things. I know it puts you in a difficult situation. If you discipline one of them, they wanna go to the other house, you discipline, you wanna go to this, they do that. That's just the way it goes. I really, are we broadcasting now? Okay, let's go off the air. McGall versus McGall.
Your Honor, I represent the movement. The issue is Mr. McGall's been arrested.
Is he incarcerated now?
He is, but he has an attorney. Mr. Psalm represents him.
Where is Mr. Song?
He's not coming because he does not object to my motion today.
That's not good enough for me.
Well, get him up. I
Well,
mean,
you can get him up here.
well, it's
You
not,
know,
I don't,
you know, I mean, the fellow's incarcerated and Mr. Soames says he's not coming up here because that's not good. So,
well, that's not under my dominion and control. It's under yours.
Not under mine either. So,
Well,
call how about the bailiff call him if you don't want to call him?
well, that would be fine.
Be good. I'll call the bailiff and then come up here. I just don't think somebody coming up and saying they're in an appearance is enough for me to protect the interests of someone who is incarcerated.
I wondered
You
about
understand
that myself, but
Yeah.
as I said, it's not my,
Understand, okay?
not my call.
Okay. Taylor versus Bach.
Good afternoon again, Judge. This case was filed in 2021 by Attorney
You want a
Cross.
trial date?
Yes,
What is the case involved?
this is a contest over a will. I represent Gail Balkman. She's here today. And she's the executrix of the estate of Vince Taylor. And I represent her in that capacity and individually. And I
You
prepared
represent Catherine Taylor. And how about Dennis Taylor? It says Catherine and Taylor, Catherine and Dennis Taylor.
Catherine Dennis, her brother and sister.
Well, you represent Dennis also?
No, I represent Gail Balkman.
I'm the plaintiff.
You represent both of these.
I'm the plaintiff.
Okay. Okay, have y'all done compliance as far as?
Your Honor, we've done,
Has there been any discovery taken?
there have been depositions taken, Your Honor. You know, candidly, the case had not had anything done on it in a couple of years, probably. And,
Hold on, send the sheriff's office to get Mr. Solomon. Thank you.
and I got Mr. Little's motion. I thought, well, I don't know if we're done with discovery. I haven't talked to my people in I don't know how long. And I would suggest that we put a schedule in for completion of discovery and then come back and get a trial date, because I don't think there's any need in getting a trial date at this point in time.
Let me respond if I may, Your Honor. I took the depositions. I completed a pretrial compliance. I completed what I believe would be okay or acceptable to your instructions. I submitted all those. He's had since 2021. He filed the case. I can understand him sitting on it because that's what he does, but we'd like to get it over with.
And I respect his position.
I don't do too much
And you
litigation.
resemble that remark.
Yeah, he
I've
does.
heard people say you resent that remark, you resemble that. remark.
But
How about, okay, is there any deposition that you think is necessary for you to take?
I don't know.
well, I took depositions of your folks. And I got discovery from you. I had to go to court to get it, but I got it.
We took Catherine, we took Dennis. We haven't taken Gail. Have we?
Well, again, I took the deposition I wanted to take.
I better take the defendant, Your Honor. Primary defendant.
Is there anybody else but the defendant?
I believe that would be all.
Okay, I want y'all to get together and schedule a date that will allow that deposition to be taken before the next rule.
Okay.
And you take it before the next rule day, you draft an order of that effect to take, and y'all come back here on the next rule day and we'll set a trial date. And that'll give you an opportunity to look at his pretrial compliance, and you do the pretrial compliance, and we'll be ready to go, okay?
Thank you, Your Honor.
Okay,
I will draft an order for you. Thank you.
yeah, no problem.
Gail, you're free to go.
Warner versus Stearns.
Let me get my file for that.
Warner versus Stearns.
Is that okay if they come up, Judge?
Sure,
Okay.
sure.
This is a case, that I filed a motion for.
Yeah, I'm familiar. We filed a motion for judgment notwithstanding the verdict, and I put it off hoping that there could be some resolution to the case as far as a right of way or an easement or something. And evidently y'all tried to do that and it wasn't possible, or.
We had a few discussions, Your Honor, and I just don't think that there's any common ground to get this one settled.
Well, quite frankly, I had reservations with how the verdict turned out. You know, not necessarily that the jury was wrong in what they did, but the different alternatives that the jury were not presented. You know, this got down the situation, but I just don't think that I've been presented sufficient grounds to overturn a jury verdict. In this case, I take jury verdicts very seriously. I quite frankly don't understand why there can't be some resolution. You know, I can vividly see in my mind the little section of land over here that would have been worth nothing less than to go down in there, but for whatever reason, it wasn't sold together in the description. I kind of would blame the master commissioner for not including that in the common description of the thing and all being sold at the same time. But for whatever reason, it wasn't done that way. And Mr. Stearns offered, in my recollection, offered the Warners an opportunity. Y'all need to hold it down there. You're keying the mic. And for whatever reason, Mr. Warner was offered the opportunity to buy that piece of property for sentimental purposes, was my testimony, with the testimony I heard. And he did, and whatever, I'm not going to impute any motives to anybody on what they did, but the jury heard the evidence. I don't know whether I would have, under the evidence, found it the same way, but it's not so far out of possibilities that I could alter, amend, or vacate. I'm very disappointed, however, that there wasn't a settlement reached where these neighbors could all use their property that are down in the bottom down there together. And I anticipate that there's something in this case that'll probably get it overturned. You know, because there's a lot of controversy in the case about what was admitted and what wasn't admitted. And I'm sure if it goes up and they go through a expense of appealing the thing, that the cost of the appeal, unless you're going to do this pro bono and do it for free, that the cost of appeal will cost your clients more than a settlement will in this case. I don't know whether you're more expensive than Mr. Little is, but you've already heard that Mr. Little is already turning down all these other cases that he's getting down here. He wouldn't even take a simple little case this morning. So I'm gonna, with some reservation, I'm gonna have to turn, to deny your motion to alter, amend, or vacate. And I've read it carefully and I've considered it. This one kind of sticks with me in a way. I don't like it too much. I just wish these people would come to a resolution that we kept this from being a problem in the future. Wasn't to be. So if you'll submit me an order or electronically file an order, and then I guess I'll put final and appealable on the thing, and you can let my bosses at the next level decide whether or not this should have been happening with it. Okay?
Would you like to hear any arguments or anything?
Well, okay, yeah, I'll let you, if you want to get something to the record. I've read the motions and relooked at things.
All right.
Go ahead.
I would like to comment about the instructions. I didn't see any errors. I prepared instructions. There was an objection to one at the last minute, but there's no manual for instructions on land cases. You just have to create them from the law. I believe they create the best that I could do. And my argument basically would be to, as it did before, no reasonable jury could find, as they did, if they went by the evidence and the law is instructed. I don't know the basis of their verdict. what they had in their minds, nobody knows. I do know that they stayed out a very short period.
Amazing, actually, as complex as the thing.
Yes, I would agree. The first instructions about apparent easement, the defendant, or that is the plaintiff, excuse me, admitted that it existed, been used by his father for years. Regarding the quasi easement, the plaintiff, Mr. Warner, stated his father purchased a small piece so he could get through to the larger piece. So the entire purpose of the purchase by his father in years past, I think approximately 60 years, was so it could be used to benefit the larger piece. So that's why I made the argument and to vacate and make a judgment notwithstanding. And that's why I think that I was surprised by the verdict. I did not connect to this jury, I would admit. I guess I'm not as good as I ever was, or maybe, but I think the jury got all the information and I think they were instructed correctly. My argument is no reasonable jury can make that finding based upon those instructions and that evidence.
Your Honor, if I could, just very briefly. Mr. Little got the instructions he wanted. I was surprised at the speed with which the jury came up with their verdict, but they got all the facts, they got all the instructions. And I think it's a bit of a stretch to say if this was a unanimous verdict, I think it's a stretch to say that we had 12 unreasonable minds all on the same jury to arrive at the verdict that they did. And we've argued this in the past before the court, so I'm not going to bring up any new arguments, but I just don't see there's any reason to overturn it and enter a judgment notwithstanding the verdict.
I'm just not gonna overturn a jury verdict that had the instructions that were requested, the arguments that were heard. Doesn't mean I would have decided that way if it had been a bench trial, but that's not the standard that I have to have. It's whether I would have decided that way. And it's just gonna have to go up. Okay?
Your Honor, can I speak?
You need to ask your attorney there, but probably not. Because you might
I
hurt.
just want to make a comment about it, so.
Here's the thing about it, Mr. The thing about it is you might very well say something that would hurt you in the appellate court. You know, that you don't mean to, that you might be honestly believe what you say. So I think it would be better if you have something that you won't say to stand away from the podium and tell your attorney that and let him make a judgment. You know, step away.
Well, I don't think there's anything to add to my argument.
Okay, that'll be fine. Well, thank y'all very much. You submit an order.
I'll talk to you in the hallway about it. Thank you, Judge.
Yeah. Butler versus McIver. Mr. Lavitt, as long as anyone, okay.
When you get to it, the grand jury's out in the hallway.
Okay, that'd be fine. Okay, the petitioner has made a motion to set a jury trial. Or for a trial date. You want a jury trial or a bench trial?
Bench trial.
Bench trial. Now, where's the other party here? You are Sherry Joe Butler, also known as Sherry McIver. Who's
Micah Guilfoyle representing.
I know, good to see you again. How are you?
See you, Judge.
Yeah. Who represents?
Judge, I'm on camera with my client. He's here in my office.
Well, you're not on camera.
I hope I am, Judge. Wait.
Somebody needs to, are you Ted's iPad? There you are. There you are. There you got it, Mr. Lavitt. Looking spiffy, Mr. Lavitt.
You know me, don't you? You know.
I know. You just had a trial with this week, you know. Okay, have y'all done trial briefs or anything on this, or tell me?
Well, Judge, there's some outstanding discovery at this time.
Tell me what it is. Tell me what it is, Mr. Lavitt.
It's asking counsel through our client to produce certain financial documents.
Would you tell us? Could you tell us what they are?
They are closing records of a real estate business.
Give us a little bit more.
And bank statements in support. We've asked for those two things and
Wait, you're talking about closing statements of all the pieces of real estate that they've closed? Is that what you're asking?
Yes.
yes, Your Honor,
Between what time periods?
just the time periods for 2019,
18 to 24, 18 to 23.
18 to 23, 2018 through 2023.
That's 5 years worth of closing statements. You know, and you want what kind of bank records do you want?
All accounts.
The accounts that support the closing records, Judge.
So that would be the business bank records
That's correct.
Used to do the closings.
Yeah.
Okay.
I think if we get that, we'll be ready maybe to settle this case.
Yeah.
I believe so, Judge.
Okay, well.
We went to Louisville for
Step away from the
mediation.
podium and consult with your client, see how long it would take to get those records together.
Judge, it wouldn't take long. I can already tell you that. We discussed
Yeah.
it yesterday. The discovery was propounded last week.
Yeah.
So I think she has them today. Most of them have already been provided.
Well, let's provide those within 15 days or something. Today is September the 11th. Our next rule day here is October the 9th. I would suggest that you provide those bank records within 15 days. Mr. Lavitt, that'll give you an opportunity to see if what is provided would be sufficient. You're wanting the closing statements between 2018 and 2023 and the bank statements that were used to effectuate those closings. That's what you want, correct?
Yes, sir.
Okay, well, they'll be to you within 15 days. And then if y'all can agree to that, you can call my office and we get a trial date. But they'll still give you some time to comply with the local rule. Even though it's not a jury trial, I will still want kind of a statement of the case and authorities, and if it's a thing of first impression and that sort of thing to get me up on it. And we can give you a trial pretty quickly. We're not, since we don't have to bring a jury. Yeah. Well, I thought there was there's not a separate business case. It's just part of the.
It's part of the divorce
Okay,
case.
well, we can do one quickly because
Judge, I just have one thing to add.
yeah.
We were prepared to send them a confidentiality agreement. Those closing documents contain information about clients. And we're concerned that financial information will get out.
You
with
go ahead and
folks.
send a confidentiality statement.
Okay.
And Mr. Lavitt, you can.
I'm not going to tell anybody.
What?
I'm not going to tell anybody, Judge.
I know it. I appreciate your.
We're not concerned with them.
But here's the thing about it, is what I'm going to tell you, the confidentiality statement are to be in your office. They can be reviewed by you and your client, but your client will not make copies of those documents, shall not write down any notes about those documents, any consultation about those documents can be in your office. And as a member of the bar, you'll protect that information. And I want that in the order. Okay? It's not unusual to ask for that. So I'll be expecting to hear back from y'all, and hopefully hope springs eternal that once that information gets over there, y'all can schedule this, settle it. If you can't, so we're going to go top to bottom on this divorce case.
Financial assets, yes, no child. There's nothing regarding a minor.
Okay, well, I'm prepared to do that. I've
Judge,
spent days of my life and gotten less than that.
Well, yeah.
Yeah. Okay. Well, thank y'all very much.
Thank you, Judge.
Yeah.
Appreciate it. Good to
Have a
see you.
safe trip
May I
back.
be excused?
Yeah.
Thank you.
Good afternoon, Your Honor.
Good. It's nice seeing you again, Mr. Lavitt.
It's good to see you too, Judge.
Mr. Soames' office is locked. He says he's gonna be back at 2:30. I just walked down.
Well, just leave a note on his door to come up here as soon as possible.
Send it to
Yeah. Okay, would y'all clear this area over here for a minute? You can move over to these chairs here. We're gonna bring the grand jury in. Mr. Lavitte's still on there. He'll be on there for days.
I'm trying to get off. Hell, I don't know anything about this.
We'll help you, Mr. Lavitt.
Thank you, Judge. I need help.
Got it. Bring grand jury. All rise for the grand jury, please. Okay, ladies and gentlemen, the grand jury, thank you. Everybody be seated in the courtroom. Who is the foreperson of the grand jury? Madam foreperson, if 9 or more of you agreed on your decisions that you made, would you hand it to the bailiff so I can take a look at it? Thank you so much. Okay, everything seems to be in order here. I'll take a look at these things with my staff attorney and we'll make a decision on what kind of bonds or arrest warrants need to be issued. If people are already in custody, we could very well do a summons to get them in front of the court. Especially, I want to thank y'all for your service on the grand jury. You're not finished yet, but on September the 11th, 24 years ago today, most of us remember where we were. We saw an attack upon not only our nation, but upon our system by people who would want to take the authority that is vested in you and the protections that our Constitution affords all of us, would like to take those away. So you're being here today, and us being here in court is really a celebration of the fact that they did not prevail. And we should all be thankful for that. I know I'm thankful for that. And tonight, before I close my eyes, I'm going to say a prayer of thank you to the good Lord for protecting, providing us, and say a prayer for the families that still hurt every day for the losses they suffered and for the brave people that went in those buildings there to try to help them. So today's the day that we should celebrate that. And I'm going to do that in my own life. And I encourage you to do it. Now, you're going to be back on October the 9th, unless we have insurrection or riots. And it doesn't look like there might be insurrection or riots or need for a special jury, but you can't ever tell. So keep your phone on. So all rise to the grand jury. We'll see y'all here on October the 9th. Okay, everybody be seated. The next case on the docket is Talbot versus Haddix.
No, Talbot and Haddix versus Mercer, Your Honor.
Yeah, there it is. It's Talbot and Haddix, administrators of the estate of John Weldon versus the unknown heirs of Shannon Mercer and others. Is that
Yes.
correct?
Your Honor, I believe we've tendered a judgment and order of sale in the file on this. We got everybody served. It's and got her $200 paid. So Megan I believe it's in there, isn't it?
So look in the file and see if the $200 is.
I know the 200. I think I told her to bring it over when we brought the $200. If not, we'll send it over.
We filed a paper with that.
Come up, sir.
Back in July.
Just come around here where we can hear you. Yeah, and sir, what's your name?
Billy Mercer.
Hello, Mr. Mercer. Now, what is your, are you one of the heirs of Shannon Mercer?
I'm his brother.
Shannon's
And his other brother's.
Okay, well, it's good. Now, what is this? You listen very carefully what's going on here and, yeah,
It's a true prong suit. It's an indivisibility suit because Bill Talbot had bought Charlotte Mercer's interest. And it is a suit to enforce a lien that Haddix has had against Shannon Mercer's party. So
so
it's
it's just against Shannon Mercer's part that the lien.
on the
is.
lien, yes.
And what interest in the entire estate did Shannon Mercer?
I believe it's 9/40ths, I believe.
940, so it wouldn't affect any of the rest
No,
folks.
no, the only,
We actually have deeds from my grandmother that's passed away and my father. And it's not showing that they left Shannon. Excuse me, Shannon. So.
Well, here's the problem. This lawsuit has been filed and there have not been any answers filed here, so
Excuse me, I'm sorry, Judge. We did file a paper back in July. And
What kind of
answered
paper?
that. Judge Staley put it with his paperwork in there.
Well, I'm not aware of that. You just can't file a paper and not serve the other parties and stuff.
So we came and talked to Jake about it, and he said to write a letter contesting it, that we wanted to contest it.
Well, that was not good advice.
Listen.
I mean, I'm sure it was well intended, but
commercial, it's a 2 acre tract, less 1 acre that's been sold off. There may be some confusion about that, but all we're selling is 1 acre. Or all we're attempting to sell.
well, I'm, the thing about it is there is a document that is filed here. It probably was not served on.
No, I haven't seen it.
Okay, see, to file an answer, you can represent yourself in a case like this, but to do that, you still have to follow the rules and you have to file an answer. If this is an answer, and I'll read it later, and you have to serve it on the plaintiff's lawyer and stuff, so they'll know.
We didn't know that.
I know that. That's the reason. If you do that, all these lawyers here would be out of business. I mean, that's just the way it is.
Can I look at what he's filed to see if
Sure.
it's got any relevance?
Well, I'm not gonna let you look at it right now, but you can have it, and what I'm gonna do is allow you to take it maybe back in the room there today while some of this family is here, and maybe you could sit down with them and talk about it. I'm not gonna enter a judgment today because of this sort of thing, and because he is relied upon what he says the clerk told him that he could do. I'm gonna give him some time, and if y'all can't work something out, I'll give him an opportunity to file an answer. And then you can file a motion. Is there anything on these 2 acres or what is it?
Old hovel.
My grandmother's old house is falling in,
Yeah.
and my brother's old trailer.
Yeah, okay, well, why don't you hand this to Mr. Cross? How many other members of your family are here? Is you and your brother here?
My brother, his wife, my wife.
Okay, well, there's room back there for y'all to talk about. And do you think that I need to send a bailiff to protect y'all from Mr. Cross back there? He looks like you can probably take care of yourself back there. I'm not making light of your situation. I just want to make sure you get protected and y'all know what's going on here, okay?
Yes, sir.
Okay.
Bill, come on.
Where's Mr. Solomon?
He's on his way. He's here.
Yeah. Mr. Cross, Mr. Solomon is here. As soon as you finish the case that you're going back on there, we'll take up the case that Mr. Solomon is here on. Okay. Now, Smith versus Byers Smith, is Mr. Cross involved in that? Okay. Okay, this says it's a motion to return non-marital property.
Specifically, Your Honor, it's an ATV that belongs to his
You
employer.
come over this way and
It's an ATV that belongs to Mr. Smith's employer,
who is his employer?
the Trooper Island, so Kentucky State Police.
Your Honor, we got a letter furnished to us, I think it was today or late yesterday, from Trooper Island saying it was an item loaned to Mr. Smith for his use, so we don't have any objection to either someone else or Mr. Smith picking that up.
Okay,
We just didn't know in the beginning if it was marital, it hadn't been
I
proven.
understand. How close to the park y'all live?
We're less than 2 minutes away.
Yeah.
Pretty much.
Well, I think it'd be, if they'd send a trooper up there to drive it off, would be the safest thing.
Don't care if it gets it there.
Well, I'm just trying to protect you. If you don't care if he comes and gets it, that's all right. But I would advise him not to come get it because if he comes and gets it and anything else gets gone, you might think he got it. So, you know what I mean? So I would just suggest that you enter an order and say that she has no objection to somebody picking it up, but the court suggests that they send a trooper up there to get it and drive it off the property. That way there won't be any doubt, okay? Thank y'all very much.
Your Honor, there's a couple other issues.
Oh, I was.
Your Honor, I had filed a motion from for status quo order, and I have that to tender to the court so that no
Well,
marital
wait just a
assets.
second. Let's talk before you start tendering me an order. Let me hear what it's about.
Okay. This is a status quo order in regard to any marital property that's in either party's possession. It would be mutual, that nobody sell or dispose of any of the property.
Well, there's no objection to that. Okay, and what else do you have?
That's all I think of our
Do you have
motions.
anything else now? How close to y'all are y'all to,
We're actually gonna have a discussion tomorrow about some of the debts and try to work through some of that, so I wouldn't necessarily oppose setting here a date if the other side wanted that. I just asked if we set it out maybe at least 2 months, just to make sure we've got everything in order.
I'm not understanding what you're saying. Y'all gonna meet tomorrow? Move over this way,
Sorry.
let him get behind the podium. Y'all gonna meet tomorrow to discuss settling this thing?
We are gonna meet to talk about debt. I don't know that we'll have an agreement on custody visitation issues, but I feel like we could probably get pretty close on the debt issues.
Your Honor, I had forgotten, that was another motion that I had filed, that he pay half of the marital debt. Mr. Bell and I talked prior to this hearing and decided that we would get together all the credit card debt to each other tomorrow, and each of them would pay half
Okay.
of it.
Okay, that'll be fine.
And then the only last issue is, court recalls last time we were here, there was a temporary visitation order set. And we also had this day set for a review to kind of see how that was going.
How is that going?
It's going well. My client has completed I'm gonna call it a parenting class. I think y'all have a particular name for that program he has to go to. He's already
That's good
completed.
enough. Do you have any problem with visitations going on?
My client has had some concerns about the child returning with some injuries, and
How old is the child?
he's just turned 3 earlier this year, yeah.
Yeah, well, if you have any documentation that you feel like there's been any abuse of the child, you can bring that, but were they cigarette burns or what were this bumps and bruises and scrapes or what?
He came back with a bloody nose twice, and he's never had one of those before, Your Honor. And he came back with bruises behind his ears
Yeah,
that he's never had.
we are very blessed that he hadn't broken something by now, I mean, children knock around. Y'all can talk about that when you're talking about the debts and then see if there's any kind of explanation of that you can have while you got some attorneys present, see if there's any problem. Does the child bruise easily? Not easy. Well, nosebleeds bother me when I hear a child, has nosebleeds. There are other reasons other than bumping into things, there might be some kind of health issue there if there's a nosebleed, so. Did you have the child examined by a physician after they came back?
I did 7:30.
Well,
Your Honor, what we had hoped is, my side had hoped is, given that we had a temporary arrangement that had limited time, we would be asking to increase that time.
we can do that, but not today. But, we won't, if y'all need to reach some kind of agreement, and then if you can't reach an agreement on this, I don't want to get so many different things going on here that there's linkage. I'd rather have an overall sort of thing if we can, with everybody being reasonable about visitation. And if in the future the child comes home with any injury, then either one of you need to document. If something happens to a child that you believe needs medical attention, is to protect you also, to protect him and get documentation. And how old is the child now? Did you say?
3.
Well, he's not gonna be able to tell much what happened to him at 3, but maybe he will be. I don't know. So, okay, well, thank y'all very much. You gonna prepare orders, submit it to him?
I will prepare an order, with Mr. Bell's help. Maybe we'll look at
Yeah,
that
okay.
tomorrow.
I don't care to worry about the, for being all that.
Okay. See you later.
Thank you.
State Farm Mutual Automobile versus Lori Stock. Do I have this motion? State Farm Mutual Automobile Insurance versus Lori Stockton. Do you have a copy of that file? It's not on, I don't have a copy of the motion. Is anybody on Zoom that has interest in this case? Nobody's on Zoom, okay. Thank you. Well, this was scheduled for 1:30. It was filed by Morgan, Atkins, and Jackson from Lexington, Kentucky. It was served upon C. Daniel Scott. Yeah, well, nobody appeared on this, so I'll just pass over. It has to do with arbitration and order to declare arbitration and when parties contact me again, I'll reschedule it. Okay, well, let's go off the record just for a second. We have some people that are negotiating some things. What's the case that Beatrice signed? McGall case. Go over there and knock on the door, Mr. Bailey, and have Mr. Cross come out here for the McGall case just for a second. That negotiation he's in back there could take a while. That would be it. Tell me.
Haven't checked 30 seconds. No, it's 30 seconds.
Mr. Cross, I don't want to interfere. You can go back there if you hadn't finished, but Mr. Solomon, Mr. Solomon is here. Mr. Solomon, y'all come back around. Is Ms. McGall here?
Ms. McGough?
Okay. And if you want to make an announcement with these people present, we can.
Yeah.
Okay, this is McGall versus McGall, 21 CI 0094. Now, previously, it was brought to our attention that Mr. McGall was incarcerated and that Mr. Soam has done an entry of appearance for him. Is that correct?
That's correct.
Okay. Now, what relief did you want?
Your Honor, we'd like visitation suspended until further order of this court. the plea, he's in jail, he's probably gonna go to read.
Have you talked to the?
Yes, I have. Your Honor.
Does he have any objection to that?
No, if you, after your last hearing, you give me 30 days to file a response. He came to see me right after that. But then he had a bad
filed a
weekend.
response.
But he had a bad weekend and we both decided it.
He's had a bad
Waste
month.
your time.
Yeah.
So you talked to him and he has no, as his counsel of record, you're stating that he has no objection to
That's correct.
suspending this until it's over. Okay,
Part of his decision.
okay, well, I'll enter that and I'll take your word for it.
Thank you, Your Honor.
Okay, thank y'all very much.
Thank you.
Yeah,
Your Honor, we have an announcement on this Talbot versus Mercer case.
okay,
Mercer brothers, y'all want to come up?
yeah.
Your Honor.
Wait till they get up here. Okay,
Your Honor, in the record is a response, but I don't think there's really any issue about the relief
Well, let's
that I'm
just-
seeking.
but let's get to the
But these fellows would like to avoid a commissioner's sale, and I'm going to give them an opportunity to do that. I'm going to speak to Mr. Talbot, and I'm going to speak to Ms. Haddix and see if we can come to terms with Billy Mercer regarding purchasing them or purchasing their interest. But Ms. Haddix is supposed to be in next week to see me, so
How much is the lien for a funeral or something?
yeah.
Who's funeral?
For gas. Oh, gas bill, I'm sorry. It's been a while, years ago.
Gas bill.
Yeah. And so what I would suggest we do is sit on this for about 14 days, and if I,
How much is the lien for the gas?
$2,400 plus interest.
$2,400 worth of gas?
Oh, yeah.
That was my exact.
Do what?
I said that was my reaction.
They let him build it up over 2 years. That was collected.
I didn't, Mr. Little filed the original suit. I don't have any.
Bottle gas, what's it like?
Yes. Mhm.
Well, it could get pretty steep bottle gas.
Mr. Haddix had a whole lot of accounts when he died. So anyway, but if you want to just sit on this for a couple of weeks.
So you had the bottle gas bill.
Yes.
And what was the rest of it? The other was the indivisibility?
Bill Talbot owns a 9/40th interest, so he's filed an indivisibility.
Yeah.
That's count one, and Haddix is count two.
And we're just trying to purchase the land, Your Honor.
Yeah.
It's been in our family since our grandmother.
Yeah, I understand.
We just want to
It
keep.
might be cheaper to put it in the commissioner's cell if it's not gonna bring it.
I'm gonna give them an opportunity, Your Honor. That's what they
You
want.
ought to talk to somebody like that, because if you don't think it's gonna bring in as much as that gas bill is. See, a commissioner's sale can never cost you more than the land brings. Okay, I mean, that's one thing about the master commissioner situation. They sell it and there's a schedule somewhere. So I said they can take a percentage and advertise and things like that, but it can never bring more. Would you agree with that?
Yes.
So, I mean.
Yeah. I'll talk to
You don't
my
have to
people.
worry about, getting a master commissioner bill for $8,000 on a $2,000 piece of property. So, okay, well, thank y'all very much.
You'll be here, probably.
Okay. Okay, on the Dickin case, have we had any conversation about that?
Yeah, they're making headway. I've left them alone.
Like that.
Oh, they are back. Okay. Boo, y'all got it worked out? Yeah.
Okay, we'll come up here and let's announce.
I told them they did better sometimes when lawyers aren't in the room.
Don't tell people that, well, you'd all starve to death if you told people to reach agreements without. Okay, let's go ahead and somebody announce what's going on here.
Who wants, Boo, you want to recite what y'all have done, and you listen very carefully.
We just all, we're just gonna go back to the way we was with our days, and I think that we're going to, try to alternate some weekends.
Yeah.
Where I get them on the weekend some. And, other than that, just about like we've been doing.
Okay, well, Mr. Cross, is that what you agreed to do?
Yes, sir.
Okay, now boys or young men, you're all big enough young men. You're the ones who are gonna make this work here. By, respecting that your parents are doing the best they can to try to get along. Now, I'm serious about that football thing. I'm gonna tell you what, are you a junior, sophomore, or freshman? Well,
He.
I tell you what, I would order if Cumberland County had a football team, I'd swear that you couldn't come go be a Bulldog and come over to Burksville, but we don't have a football team and we know we don't want to send you to Wayne County to play football. But it's an important part of your life. And are you playing already? Is that right?
Yeah.
What do you play? A halfback, quarterback, defensive?
Play mainly linebacker and the end.
Yeah.
Some.
You're a defensive specialist. That's right.
Some
Okay. Well, good. Well, let's see if we can't work through that. Mr. Cross, you know some people out there that in that program.
Mr. Talent, Mr. Coach, and Mr. Dickon live about, well, they're Mr. Talent's father and Mr. Dickon live a stone's throw apart, so I think he can talk to Rob.
See if you can work it
he
out,
really
tell
wants
him
to get back on.
that there was pressure, that they were going through some difficult times. See if they give a boys a break. Let
And
them
they need
come back.
numbers.
Yeah.
They need numbers.
And then when football season starts, I expect to come back and see y'all hit somebody. Okay, thank y'all very much. Is there any other matter to come before the court?
Wanda and I've got something you're on.
Okay, well, y'all,
You can come back to me, let's go over this where I can write up your.
okay, yeah. Were you ever get a hold of your client?
Yes, sir.
They're here, okay. Okay, let's go off the record just for. Which, this is the, case that wasn't on the docket. Give me the file.
Yes,
You want?
Y'all want to.
We don't have the file here on that. What, did you have a file? You showed them the motion, I guess, earlier.
It's not, it was the one that, it's not on the docket, but the order was supposed to have something on.
What's the name?
it is Laura Claiborne and Marcus Riddle versus Catherine. It's case number 25-CI-25.
Well, I thought we pulled it out a while ago and looked. I guess they pulled.
No, they just showed us
pulled it
the
out of there.
Do you want the last court order? Would that
I
help?
just wanted to file general.
She's never seen it.
Well, David, it's.
Yeah.
That's the way it's going. That's all we got.
Yeah.
Okay.
We're just sitting across the hall, get the file.
I think the Mercer should have been football team.
That's the truth.
It's a big deal.
Floyd was a good basketball player. Floyd was.
I remember, this picture in my brother's yearbook.
Yeah, he was a decent,
Let's go off the record here. This is 25 CI 0025, Lori Claiborne. And then Marcus Riddle now, adult versus Leslie Ketchum. Okay, what we got going on?
Your Honor, this is a case in which there was a GAL appointed, that was Ms. Perigin, that recommended that they work with a graduated schedule to get to 50-50. And they've been, there's been visitation, and we've graduated it up. My client had also initially asked that the child's name be changed to Riddle. And he's requesting that that occur, as well as,
Well, that is that's the sort of thing that blows up visitation issues. I mean, at some juncture, the child can decide what the child's name. Are they married to each other?
no, Your Honor.
Well, here, that's the problem. With people that don't get married, they cannot scotch their name on a child necessarily that both sides have got. So let's keep that out of the mix there. And when the child gets older, the child can decide where they want to be at. It's going by Claiborne now or Catherine or what's?
Catherine.
Catherine. Then the child can decide whether it's a Catherine or a Riddle later on. So I'm not going to go into that. That's not anything you people can agree on. There's no factual basis to do one or the other. So just tell me real quickly what the contention is besides that.
Well, my client's,
What does your client want? Just tell me. I don't
he's
want
wanting
to go.
50-50
Well,
time.
how much is he going now?
Right now, he has every other weekend, Saturday overnight, and on the other Saturday, he has a few hours, and he has Wednesday night. Wednesday not overnight, it's a couple of hours.
And what does your client want?
He would, right
I
now,
know he wants 50-50. Hey, ma'am, wait a second. You want a break here? Let's take a break. You can go there and talk to him. I'm not gonna have you distract from your turn. Is this the grandmother? Okay, is this the grandmother here?
Yeah, because she's not of age.
I thought she was of age now.
No.
It's
He
just,
wasn't of age when it began, but.
He's now of age.
he's of age now. Okay, I got you. I knew one of you had become of age and I guess it was you. Okay, go ahead. What's your client wanting?
Your Honor, I think Mr. Riddle's a pretty industrious young man because he's working two jobs.